Welcome to today's webinar. My name is Brian Lamb. I am the practice group leader for Thompson Hine's Business Litigation Group and a partner in our Cleveland office. Before we begin, a few housekeeping items. One, today's program is being recorded and we will send a link to all attendees, including the presentation slides, within 48 hours of completion of today's presentation. Two, if you have any questions during the webinar, feel free to use the question box located in the control panel on the right side of your screen to submit questions. Laura and I will monitor the questions as they come in and try to answer them as we can. We have set aside time at the end of the webinar to answer questions as well. Presenting with me today, I'm delighted to introduce Laura Ryan, a partner in our Employee Benefits and Executive Compensation Group from our Cincinnati office. For approximately the next hour, we will present information on this very large, complex proposed class action settlement. We will also address what affected employers can do to protect their rights, potentially file a claim, and prepare for questions from your current and former employees. We will leave some time at the end to address as many questions as possible. Laura and I have worked through a number of our own questions, some of which we acknowledge at the outset are not yet resolved in our own minds. The good news is that employers and their counselors still have time to sort through the issues before any meaningful deadlines arrive. Thank you for your interest. And now we will begin the webinar. Our agenda today, I will start by giving an overview of the antitrust lawsuit that brings us here today. Then I will dive into the details of the proposed class settlement. Then we will turn it over to the real show, Laura, who will take us through some fiduciary considerations that are generated by virtue of this proposed class action settlement. And she will discuss action steps that employers should consider taking. We're going to talk about both monetary relief and injunctive relief as part of the action steps. So let's dive right in. What is this lawsuit about? The plaintiffs are subscribers, that is insureds, and providers, that is doctors and hospitals, who claim that the Blue Cross Blue Shield Association and 37 settling individual Blue affiliates, that is separate Blue Cross insurance companies, violated antitrust laws by restraining competition between and among them in the markets for health insurance and administration. The plaintiffs allege that the Blue Cross entities, one, artificially inflated premiums for fully insured plans, two, artificially inflated administrative fees in the case of self-funded plans, and three, diminished consumer choice. Laura and I have no point of view today on whether these allegations are true or what defenses the Blue Cross entities might have. Our concern is solely what effect does this proposed settlement have on employers who offer sponsored health insurance plans. So who are the settling plaintiffs? There's three types: fully insured individuals. So that's Joe Bag of Donuts. If he went out and purchased insurance directly from a Blue Cross entity, he is a class member. Fully insured groups and their employees. So if Acme Incorporated went out and purchased a fully insured product from a Blue Cross entity, Acme is a class member, as are the employees of Acme who purchased insurance through that plan. And third, self-funded accounts and their employees. So if Acme was self-funded and took all the risk related to insurance losses, but hired a Blue Cross entity to do the administration, then they are also class members here, along with their employees. It's very important, and we will discuss this throughout, that employees can make their own direct claims against the settlement trust, even if the employer was the sponsor of the plan. I'll repeat that. Employers are in the settlement class. Employees, current and former, to the extent they were employed during the class period, can make their own claims directly against the settlement trust. But note, dependents, beneficiaries, and non-employees are not eligible to receive payment. They are not class members. So it's for an employer account, the employer is a class member and can submit a claim. and their employees can submit claims, but not their employees, for example, spouses or children. Who are the settling defendants? It's the Blue Cross Blue Shield Association and 37 separately named settling individual blue affiliates. Now that's a mouthful. What does it mean? It would help to give a little description of how Blue Cross operates, though I do not pretend to have mastered the intricacies of the Blue Cross world. There are 37 insurance companies who are part of the Blue Cross world. They have license agreements in which they receive licenses from the Blue Cross Blue Shield Association to use the blue trademarks, Blue Cross Blue Shield, and to sell insurance services and products using the Blue Cross name. And those 37 entities are also part of the settlement here. One thing to understand as you listen to how this rolls out, most of these Blue Cross insurance companies, if not all of them, can and do offer some non-Blue Shield related products. Those are called green products for purposes of the settlement here. So there's blue activities. That's when a Blue Cross affiliate is using its Blue Cross relationship to sell services and products. And then there's the non-blue or the green side of their business, where the entity, the insurance company, is selling insurance but not using the Blue Cross name. And what ties both of these blocks together is that all of the settling individual blue affiliates are subject to the same rules of governance and policies and procedures created by the Blue Cross Blue Shield Association. And it is those rules of governance that the plaintiffs in the case allege were anti-competitive and violated federal antitrust laws. So to be more specific about who are the settling blue affiliates, attached to the settlement agreement and repeated here is, this is a 2-slide list of the settling blue affiliates. So in bold is the name of the Blue Cross affiliate, and next to that is the state in which they have their principal license. For example, Blue Cross Blue Shield of Kansas City may have its principal license in Missouri, but its insurance could cover anybody in all 50 states or even beyond. But they have a principal place where their principal license exists. One thing to note about this slide and the next one is that the name Blue Cross or Blue Shield does not necessarily appear in the name of all of these blue affiliates. For example, the last one, Wellmark Inc., is a settling individual blue affiliate, but it doesn't even have the word Blue Cross or Blue Shield in its name, and you might not even really think of it as a Blue Cross plan. If you're involved in administration of the plan, you probably are aware of the relationship, but your employees might miss the connection there. So when we send out this slide deck, you will be able to see, again, here's the first page in alphabetical order. Here's the second page. You'll be able to scrutinize this more closely, particularly when you hear that we're going back in time as far as 2008, and many of you may be affiliated with companies who have changed their insurance companies over the years, and so you will probably want to scour this list more closely when you have time to figure out if your company is affected by this settlement. There are 3 settlement classes, okay? That is the plaintiff side of things. And you know, the way a class action works, a handful of plaintiffs agree to serve as representatives of absent class members, people who are not even involved in the litigation. And they are representatives of the class. And if there's going to be a class-based settlement, the federal court must approve the settlement. The court acts as a watchdog to make sure that the proposed settlement is fair to the absent class members. So these are the absent class members are the fully insured individuals, the fully insured groups and their employees, and the self-funded groups and their employees. Okay, there are tens of millions of class members according to Blue Cross. Though each company or individual has relatively small claims on their own, these claims are massive in the aggregate. Okay, the one way to think about the settlement is in two parts. First, there's the nationwide injunctive relief class, injunction being something other than the payment of money. And in this case, it's Blue Cross and its affiliates agreeing to change their rules of governance and other rules and procedures by which they govern themselves. They're agreeing to change those things for purposes of settling this class action. The other part of the class settlement is monetary, and it's broken into two pieces. There's a nationwide damages class, which focuses on the fully insured plans and members. And then there's the nationwide self-funded subclass, which focuses on the self-funded plans and the employees of these self-funded plans. So you think of it injunctive versus monetary, and think of the monetary as fully insured versus self-funded. So let's jump into what is some of this injunctive relief. And I should say, I'm going to take you through a handful of slides here on the injunctive relief. For most of them, there's nothing that you need to worry about doing. This is Blue Cross and its affiliates agreeing to change the way they do business. There is one exception to that, which I will draw your attention to when we get to it. But first, and I think the plaintiffs think this is one of the most important gives in the settlement, is Blue Cross agreed to eliminate what they called their national best efforts standard. Under the current system for each of these Blue affiliates, at least 66% of their national revenue had to come from the blue side, as opposed to what I mentioned earlier, the green side. So they were agreeing they had to devote at least a certain percentage of their business, 2/3 of it, to the blue business. The plaintiffs say that this restrained affiliates' ability to compete against each other. It disincentivized the use of the green business, and it thwarted acquisitions of non-blue brand by non-blue branded health insurers like Cigna. Like if Cigna bought one of these blue affiliates, Cigna would be bound by this rule that 66% of the national revenue had to be Blue Cross related. So as part of the settlement, Blue Cross has agreed to eliminate the national best effort standard. And they agreed they will institute no similar restraint in the future. The result, according to the plaintiffs, is what they told the judge, that they and their experts believe this will result in more green on blue competition. So they say it is good for the marketplace. Okay, this one, if you're a large account, if you have more than 5,000 employees, you should perk up and pay attention on this one. The right to request a second blue bid. One of Blue Cross's rules in the current system is that large national accounts generally get only one bid from a blue affiliate. So if you are Acme Global Corp and you have 10,000 employees and you want to place your business for health insurance, under the current structure, Blue Cross will only allow you to get one bid from a blue. Okay, so that means two blues aren't competing against each other and potentially driving the price down. The plaintiffs believe that that was anti-competitive. So the settlement guarantees that certain eligible qualified national accounts can request a second bid from the blue affiliate of its choice. So you'd go back to the list of 37 entities that I showed before, and you could get the one that's where you're headquartered, that has the region where you're headquartered, and then you could pick any other one you wanted and say, I also want to bid from them. The idea being that this should garner more competition. The plaintiffs call this more blue on blue and green on blue competition. So the definition of qualified national accounts is a little complicated. Some of the details have still eluded my limited capacity to think about these things. First, you do have to have more than 5,000 employees, which is very straightforward, but that alone does not get you in the club of qualified national accounts. You must satisfy something called the D&B, Dun & Bradstreet analysis, such that all qualified national accounts together must meet these criteria, all of which are outside of your control and mine. So the point being, there is an appendix to the settlement agreement, which we have recreated at the end of our slides. So you will get, when you get an email, that lists the 1,042 entities that are identified in the settlement agreement as qualified national accounts. These already are going to get the right to request a second blue bid the next time they put their business up. By the way, this particular provision does not kick in until April of 2022. I know some of you plan much further in advance for that when you're sending out your bids for new work, but just keep in mind that there is a long lead time here. I think the takeaway is if you are a 5,000 plus employer, you should be looking to see if your company's name is already on the list, and if it's not, you should be asking yourself how you might go about asking to be put on the list. There is a monitoring committee which will help. It's created partly by the court, partly by the settling parties, that will help resolve disputes about such things. The major takeaway, though, is if you're small, don't worry about this one. But if you're over 5,000 employees, see if you are already qualified for this right, and if not, see if it's in your interest to get qualified. One other supposedly anti-competitive provision of the blue governance world that is being eliminated here or restricted is the use of, quote, most favored nation differentials. This was a part of the blue system which required providers, that is doctors and hospitals, to give the blue affiliate a better price than is charged to any competing insurer. Oh, that's a nice work if you can get it, right? If you have the leverage to have a doctor or hospital promise that you will always get a better price than is charged to any competing insurer. The plaintiffs allege that this had the effect of raising prices for everybody else because those doctors and hospitals had to make up for the low prices given to the blues some other way, and that's usually out of the other insurance companies. So under the settlement, Blue Cross has agreed that there will be no most favored nation differentials when the blue affiliate has greater than 40% market share in its region. Again, there's nothing you need to do about this other than be aware that changes are made. Blue Cross is making changes that should make things more competitive out in the world. Lastly, a couple of minor points on the injunctive relief. They are agreeing to eliminate certain restrictions on whether a blue affiliate may be acquired by another blue affiliate. This is kind of inside baseball. And also, they are allowing self-funded accounts to directly contract with certain specialty service providers, which in the past Blue Cross did not allow. So if you're self-funded and you do have relationships with certain doctors or hospitals or wellness centers and you want to maintain that, Blue Cross is easing up on its restrictions in that regard. So that should be good for you. Okay, switching now to show me the money, the monetary settlement fund. This is the second part of the settlement. This is the one you do need to pay attention to because you do have some decisions to make. This money does not grow on trees, and it will not appear in your bank account automatically. You must take steps to claim your share, okay? The gross settlement fund here is $2.67 billion, okay? That's billion with a B. That is a lot of money. Note the size of the attorney's fees and expenses, which are being set aside or carved out of the $2.67 billion. $667 million that will go to pay the host of attorneys who litigated these various cases against Blue Cross for many, many years, hundreds of depositions and pleadings. It really was a lot of work that the plaintiff's attorneys put in. I'll leave it up to you to decide if it was worth $667 million. But this is what the court has preliminarily approved on a going forward basis. Even the amount of the cost of giving notice to the class and administrative expenses to administer this big settlement fund is $100 million. I mean, pretty soon you're talking about real money. So when you subtract the 667 and the 100 from the gross payment being put into a pot by the Blues, you have a net settlement fund of $1.9 billion that's available to claimants to be divvied up among them. Okay, so looking at the definition of a nationwide damages class, we already saw these concepts of individual members, insured groups and covered employees, and self-funded accounts and their covered employees. Okay, these are people who can submit claims, and as long as they meet the two criteria in the boxes on the right, that is that purchased, were covered by, or were enrolled in a blue branded health benefit product, unless it was standalone vision or dental, sold, written, undershired, administered, or issued by any individual blue plan during the class period. The class period is defined as February 7, 2008. Yes, that's not a typo, 2008 through October 16, 2020, except for the self-funded group, that is the third box on the bottom left. The class period there is much shorter. It's 2015 through 2020. Okay, so this, if you fit this slide, you should be paying attention and figuring out, how do I submit a claim to try to get paid my share of the settlement fund? Okay, so there is an allocation of the net settlement fund, that 1.9 billion. It's in the structure of the settlement. 93.5% is set aside for the fully insured people. That is the fully insured individuals and the fully insured groups and their employees. That, of course, is the lion's share of the pot, 93.5%. And that makes sense because the premiums paid by those people were significantly higher because Blue Cross was buying the insurance risk. The rest of the pot goes to the self-insured world, 6.5%. So that pot is still real money in any other context. $123.5 million is set aside for claimants who were self-insured accounts or their employees from 2015 through 2020. Okay, now I don't have a slide on this, but I should have added one. The main step that happens next is, how much do I recover in your settlement, or when you submit a claim? How can I guesstimate how much I can recover? There's a challenge here. It's based on the total amount of premiums that you paid to a Blue Cross affiliate during the class period. So whatever your total premiums paid were during the class period is the numerator. The denominator is the total premiums paid by everyone else who submits a claim. Okay, so you may be able to figure out for yourself, how much did we pay in premiums for the past 5 years for our self-insured account. You could probably go figure that out if you were so motivated, but you'll only know the numerator. The denominator depends completely on how many other companies and self-insured accounts, if we're focusing on the right-hand column here, how many other claimants submit a claim. The defendants have agreed that all this money will be distributed. None of it reverts back to Blue Cross, except a certain portion relating to the notice and administration. But this pot here, the settlement pot, this money is going to be distributed to the claimants. So if one person submits a claim and the numerator is X dollars, their denominator is the same thing because they're the only person who submitted a claim. So they're going to get 100% of this pot. Unfortunately, that's not how it's going to work out because of the notice program I'm going to describe for you. Many people are expected to submit claims because Blue Cross had a lot of business during the past 5 to 13 years. Okay, so you can guesstimate only the numerator, how much you paid in premiums, but you can't really guesstimate the denominator. So it's very difficult to estimate how much money you might get if you make a claim. The good news is the costs of submitting a claim are minimal, very minimal. It's easy to do. You don't even need to go back and calculate all your premiums. The plan administrator and the Blue Crosses are going to do that for you. You literally do not need to go back and check what your premiums paid were because the defendants who are putting money in the pot and administering this, they know how much you paid in premiums during this period. So there's one more complication to figuring out how much an employer might get back. Not only are you competing against other employers who submit claims, you also are, in a way, competing with your employees, because your employees of either self-funded accounts or fully insured accounts have the right to submit claims directly to participate in this pot. Okay, so because in America, most, not necessarily all, employer-sponsored health plans include some portion of the premium that was contributed by the employee. A portion paid by the sponsor, a portion paid by the employee. They could have settled this in a way that required every company and every employee to prove what that allocation was. But they concluded that that would be a nightmare and probably very difficult to do and maybe not worth the effort. So what they did was they hired experts, they did studies, and they came up with their own default allocations between employers and employees. Okay, so these defaults are what will happen if you just submit a claim form and you click the default box. Okay, how much does the employer get versus how much goes to the employee? They have separate numbers for the fully insured world versus the self-insured world. So starting with the fully insured world, for single coverage, the default is that 15% of the premium for a claiming employee is considered to have been paid by the employee. Okay, 15% of the premium, and remember, they're going to calculate Acme's total premiums paid during the class period, but they know that a portion of that total amount would have been contributed by employees who could make claims. So they're saying, if you don't do anything else, we're going to assume 15% was considered paid by the employee in a single situation. In the family situation, we're going to assume 34% of the premium for a claiming employee with family coverage, that's how much they paid. It's rough justice. They know that in the real world, this is an average number. It's not the actual number for any particular company. And this raises issues that Laura's going to discuss if you are an employer and you know that your default allocation was different than this, particularly the more materially different it was, the more of an issue it raises. On the self-insured side, if you're a self-insured employer, for single coverage, they're assuming that 18% of the premium for a claiming employee is considered paid by the employee. And for family coverage, 25% of the premium is considered paid by the employee. So those will be the defaults when after you submit a claim and they figure out how much does your company get versus every other company, then of the portion your company gets, how much of it should be allocated for claiming employees. Okay, so what the plan of distribution here has a couple of different assumptions built into it, and this is what the settling parties explained to the court. They're coming up with a balance between precision and efficiency. They know these percentages are not, accurate in some Aristotelian sense. They are rough justice, okay? Because they don't want to make people have to do a lot of work in order to submit a claim for fear that people will not submit claims. So they've also included multiple different methods and channels of notice about this settlement to ensure that all the potential class members receive notice so that they know to submit a claim. The notice program here is about as sophisticated as I've ever seen in a class action settlement. It includes, they will send email notice directly to anyone that Blue Cross has, any class member that Blue Cross has in their system. If they have an email for them, just in the course of ordinary business, they got the email of your employees, they will use those emails to send out notice of the class directly to your current and former employees. If they don't have an email address, they will mail a postcard to the last known mailing address. And beyond that, they have a sophisticated media approach. They're going to post ads on Facebook, Google. They're going to be on ads on CNN, HGTV. They're going to put ads in People magazine and Better Homes and Gardens. They have a very complete and sophisticated plan to encourage as many people as possible, as many people that are in the class, to put their claims in. And of course, this is constitutionally required because every one of those class members is going to be deemed to have released their claims against Blue Cross as a result of this settlement. And the Constitution requires that they at least be given notice and an opportunity to object if they're going to be bound by a settlement in a case in which they were not an actual party. The plan proponents go on to say that they give every damaged class member, including employees, an opportunity to make a claim. They've come up with an automated process to identify valid claims and provide payment. You do not have to provide years of premium data or contribution percentages. You do not have to do that. It's really good news. If you accept the default options, then you don't have to provide any further data. But both employers and employees can choose, if they want to, an alternative default allocation, or alternative allocation, but they must be prepared to provide additional information to be reviewed and adjudicated by the settlement administrator. So if you were an employer and you know that you paid 100% of all premiums, you never passed any of that cost on directly or indirectly to your employees, well, it might be worth your while to submit proof of that to this settlement administrator and say, well, I want the company to keep 100%. None of it should go to any employee who submits a claim. Okay.
Hey, Brian.
Yes, Laura.
Can I interrupt for just a second? We've gotten a couple questions, and I think they reveal that we're being a little bit loose in our terminology, both on the slides and in our words. I think we're tending to refer to premiums. But just to be clear, premiums is a concept that applies to a fully insured plan where you're paying a defined premium to the insurance carrier for the applicable coverage. In the self-insured arrangement, we probably should more accurately be referring to the administrative fees that you paid to the Blue TPA to administer your self-funded plan. We don't really have something the equivalent of a premium in a self-funded world. It's really the administrative fee. So I think people are getting a little bit confused, and some of that is probably our fault. When we're talking about self-funded, we're really focused on what was the total administrative fees that employer paid to the Blue affiliate to, be the TPA claims administrator for the self-insured plan versus a fully insured plan where we really are talking about a premium being paid.
Yes, I agree 100%, Laura. That is very good. I apologize for being loose. And the settlement agreement is very clear, as is the notice. When it refers to self-funded plans, they use the phrase of administrative expenses, and that's what you would be calculating. That's what your claim would be based on, your share of those. Yeah. So last couple slides on the background of the settlement here. They have some if-then scenarios described on the website. There is a website, which I'm going to show you where it is, where you can go get information about the settlement. They have things like, if the group files a claim, but no employee for that group files a claim, then the group's share will be calculated from the full premium. See, they use the shorthand there too, or administrative expense paid by that group. So if your employees don't submit claims, they're going to send 100% of the premium or the administrative fee onto the group, the employer. Likewise, in the second row, if the group files a claim and accepts the default option, and one or more employees file a claim and accept the default option, then for each claiming employee, the default percentage will be used to calculate their premiums paid or administrative fees paid, with the remainder being allocated to the group. Okay, and then it goes on. The settlement documents have other if-then scenarios, which you can look at both in the slides when you get them and on the website. So because there are various iterations that get kind of complex for how this all works. My last slide is the upcoming settlement deadlines. The good news is you have time to sort things out. By May 31st, that plan of notice is supposed to have been completed, the advertisements, the emails, the mailings. That's to be done by May 31st. I believe it has already started. So you may be getting questions now or soon from your employees or former employees. So, hey, what does this mean? How do I submit a claim? Will you do it for me? All those kind of questions might start rolling in now because that notice is going out and will be done by May 31. By July 28, you have the deadline to opt out of the settlement. That is, if you conclude you do not wish to participate, you can opt out and your claims will not be released and you are free to go sue Blue Cross to your heart's content. Note that it takes many years and lots of attorney's fees to pursue them for antitrust claims. So I'm guessing most people will be happy to just participate in the settlement, but you do have a right to opt out if you so choose. If you don't opt out by July 28, you are deemed to be in the class and you will be bound by the settlement. There's a variation on that. By July 28, you can also object to the settlement by filing with the court an objection describing what your concern is. You're not saying you want out, you're saying you want some improvement to the settlement. It's possible there will be objections like that that affect the structure of the settlement. But if there's too many objections or if it gets changed too much, the parties have the right to walk away and abandon the settlement. October 20th is the final fairness hearing in court in Alabama, where the judge will review all the objections and hear from people and decide if he thinks that the settlement is fair and ought to be approved after hearing objections. And if he approves it, it will then be binding on anyone who did not opt out. The big one that you should be aware of is November 5th of 2021. That is the claims filing deadline. That is the deadline by which anyone who wants to submit a monetary claim has to get their paperwork in by that date. The website is live. You can go look at the claims form now. You can download a PDF of it, or you can start submitting it online, filling it out online. Of course, if the settlement does not get approved, your work will have been for naught because the settlement will evaporate. But if you wait until it's approved in the last week of October, you're giving yourself a short deadline to finish the claim form. Now, the claim form is pretty simple. It's just a couple pages and it asks things like name, rank, and serial number. It does not ask you to go back and calculate or list all your all the administrative fees or premiums that you paid. It does, though, to ask which Blue Cross entities did you do business with during the class period, and you have to list those out. So here's the website, bcbssettlement.com. There's lots of interesting information there, including FAQs, key dates, important documents, and feel free to go there and look for information. So with that, I will turn it over to Laura now, who will address some of the fiduciary considerations raised by all this.
Yeah, and before I dive right into that, I did want to, also repeat what you said and encourage folks to visit this website. If you think you're a potential class member, take a look. A lot of the information out there is, pretty straightforward and easy to read. The other thing I'm going to encourage you to do, and this is reflected in the action steps, is to take a look at the claim form. It's really an amazingly simple form, although it is about 10 pages long, I think. Really, there's just very short sections that apply to you depending on which type of class member you are, meaning are you an individual who had an individual policy? Are you a company that sponsored, a health plan, medical, dental, vision, or are you an employee who was covered under your employer's group health plan? But the other thing I want to reiterate about that, because there's a question that we received about what if I was a Blue client customer several years ago, but I no longer am a Blue customer and I don't have any kind of relationship with a Blue entity. How am I going to file a claim? Well, keep in mind, you're not submitting and filing the claim directly with the Blues or with Blue Cross Blue Shield. You're going to submit the claim through this settlement administrator website. And so you don't have to have a current relationship with a Blue or a Blue affiliate. in order to be able to submit your claim and information. Now, if you don't have some of the basic information to complete the claim form, like you don't remember exactly what entity you contracted with during that time period, or exactly what the time period was that you had the coverage. You know it was a couple of years ago, but what couple of years ago? There's also a question on the claim form asking for the group number. Depending on how long ago it is, you may not remember what the group number is. So, either you're going to have to try to do a little bit of digging in your own records to try to locate that information, or what I'm hoping, although I haven't tested, is that there will be maybe a number that you can call that's provided through the settlement website, identify who you are, who your company is, and they may be able to sort of look up that information. There's also specific instructions on the claim form directing you if you don't have certain pieces of information. I think basically, in essence, suggesting you submit, everything that you possibly can, and then hopefully, once that information that you submit is coupled with the information in Blue Cross Blue Shield's records, they'll be able to sort of validate or perfect your claim. So I think that addresses kind of a couple of questions that started to trickle in as you were speaking, Brian, and we'll come back to some other ones as well. But I did want to address and make sure that sort of your fiduciary or potential fiduciary obligations that you may have here in connection with this settlement, sort of less concerned about, the filing of the claim on behalf of the plan, but a little more focused on what your obligations may be vis-a-vis these participants or former participants in what ultimately was an ERISA governed plan. And this is focused on ERISA governed plans. Not all benefit plans are subject to ERISA. This program was designed to focus on plan sponsors and companies that sponsor ERISA governed plans. And as I hope everybody that has an ERISA governed plan knows and recognizes, there are certain ERISA fiduciary obligations that are triggered when you're dealing with these kinds of plans, making decisions about these kinds of plans, communicating with plan participants in these sorts of in ERISA governed plans. And the other piece of background that I just wanted to discuss very briefly is, this isn't the first time in history that an ERISA governed plan has been the potential recipient of either settlement proceeds in the context of litigation like this, or some other form of rebate or refund. Folks that have been doing this for a while may remember back in the day there was this proliferation of demutualization activity, which ended up resulting in demutualization payments being made in connection with that process. And of course, more recently, under the Affordable Care Act, there was this new concept of medical loss ratio rebates that insurance carriers, depending on their actual experience for the year, may have been required to rebate back to ERISA governed plans. And the DOL over the years has been pretty vocal about its views on how a plan and a plan fiduciary is supposed to view these types of receipt of proceeds, what they're supposed to do with them, whether and how they may be obligated to share these proceeds with the plan participants. I've cited here on this slide a couple of specific pieces of DOL guidance that were very specific to, for example, in the 401k plan context, a series of settlements that at one point we were seeing related to sort of like alleged trading violations being performed by certain mutual fund companies that resulted in distributions out to 401k plans. We also have a technical release from the Department of Labor issued in 2011 telling sponsors of group health plans, what their obligations may be with respect to these medical loss ratio rebates. So we do have precedents for the Department of Labor taking an interest in these settlement proceeds. And in general, where this guidance came out in the past is basically the DOL, announcing that they did not plan to sort of take issue with any court or agency approved method of allocation of proceeds, let's say, among the affected 401k plan. So they were going to kind of defer to what the court decided was an appropriate method of allocating the settlement proceeds, and it was more of like a non-enforcement. We're not going to try to enforce or review or scrutinize the court-ordered method of allocation. They also, I think helpfully indicated that just because an allocation doesn't exactly reflect, in this case, premium activity of policyholders, or in the case of the 401k settlements, the exact investment activity of the participants, doesn't mean that it fails to meet, ERISA's requirements. And also recognize that fiduciaries are permitted to weigh things like the cost to the plan, as well as the ultimate plan benefit, in determining whether a method is reasonable, fair, and objective. So it doesn't have to be precise, especially to the extent to get a precise allocation, it would take lots of time and effort and money, and ultimately really result in not any real significant difference in the actual allocations. Now, I do want to say that this guidance is not necessarily directly, doesn't directly speak to the current situation with the Blue Cross Blue Shield settlement. We may see something issued by the Department of Labor in connection with this settlement. In fact, I think that would be kind of nice for us to get, guidance from the Department of Labor that tells us how they view this proposed settlement, and the extent to which they, might challenge the allocation method or have suggestions about what fiduciaries should be doing in connection with this. Although I'm not going to hold my breath for that, because we've got to keep sort of moving through this process, and they've got a lot of other things on their plate right now, as I think anybody in the benefits world well recognizes. But the key difference here in this settlement from many of the other settlements that I alluded to is that here the plan is not filing a claim, on behalf of the plan and all of the plan participants. The way this has been structured, and I think in this regard, it's relatively unique, although I have not scoured the world to figure out if there's, another type of settlement that has been set up like this. But in this regard, each individual covered employee or, former employee is needing to and has the right and ability to file his or her own claim for his or her portion of the settlement proceeds. And so, presumably the plan is filing for their portion, the participants are filing for their portion, and there's no, hopefully need to really assess, once a plan receives their portion, do we sort of owe some portion of this portion, back to the plan participants, and what is that portion? But as we'll see, it may not be quite that straightforward. I think that things that you need to carefully think through as a fiduciary include, do we as a fiduciary have some obligation to ensure that employees and former employees are aware of this right to file a claim? Now, as Brian explained, there's already a very robust communication and notification process contemplated by the lawsuit itself. In fact, as the note at the bottom of this slide indicates, There are FAQs posted to the settlement website that explicitly state that employers are not obligated to notify employees of the settlement. That they will take care of that. I think that's great. It gives me some comfort. It doesn't, though, explicitly state that this satisfies maybe a separate or independent fiduciary obligation to make sure that your employees are aware that they have this right to file their own claim, and that that's really the only way they're going to receive a share of these settlement proceeds. The other big question that lingers out there, and again, Brian alluded to this when he was describing the default allocation that is embedded in the proposed settlement, that, what was it, 15% cost allocation for employees for single coverage in the case of fully insured plans, and 34% cost allocation to employees for the premium charge in the case of fully insured plans. That's the default. But what if the plan sponsor knows that default allocation is not closely aligned with the plan's actual cost allocation during the applicable period? Does that trigger some, fiduciary obligation to provide information to employees that they would need to basically make a claim that an alternative allocation is, more appropriate, or, more closely reflects the actual cost allocation during the applicable time periods? That's an open question, and that question should be, considered very carefully. And then, of course, should the plan sponsor file a claim? Should the plan file a claim? Should the plan choose an alternative allocation method? I mean, some of the answers to these questions are in part going to depend on the facts and circumstances of your particular situation. Again, as Brian mentioned, there is no requirement as part of the claim form to provide and confirm historical premium or administrative fee information, either as part of filing the plan's claim or as part of an employee's claim. What the Blues have said is, look, we have that information. We know, how much in premiums we received from this particular group during this particular year, or how much we received in administrative fees. And then, of course, that default allocation method is the one that's going to be used to figure out, what portion of that are we going to assume employees paid, and what portion are we going to assume employers paid. So that's what's contemplated, but it's still kind of a question. What if you actually know that default methodology doesn't reflect, the real situation? So moving away from some open questions, let's talk about some very concrete action steps that I think you should be thinking of taking. First and foremost, I think, efforts should be undertaken by you if it's not already just immediately obvious. Oh, we definitely are a class member, and here's why. Because during each of these discrete periods, we had either medical, dental, or vision, or some combination thereof through one of these Blues affiliates. I mean, unless you just sort of automatically know that information right off the top of your head for your company, then, I think you need to sort of start by really sitting down and thinking through, are we a class member? And if so, for what period? So, going back and looking at, okay, what are the applicable time periods that we're talking about? Again, that depends on whether your benefits were fully insured or self-insured. Of course, that gets complicated because many employers, they may have self-insured medical and fully insured dental and vision, for example. So, really kind of thinking through those details, and then assigning the period, which was reviewed in a prior slide. Looking at the different affiliates. Don't assume that just because you don't ever remember Blue Cross Blue Shield being your provider means that one of these Blues affiliates wasn't one of your providers. You know, making sure that, well, and then the second action step, and I've already mentioned this, is if you've done that exercise and you think, yep, we definitely have a claim here to submit for one or more of the, you know, I'll say calendar years during the applicable period, or plan years. Sometimes plans are run on a non-calendar year basis. Then I would encourage you to go out to the bcbssettlement.com website and click on the claim form. It's going to be right there, one of the first things that you can click on, and go to the section of the form labeled businesses. So that's the section you're going to have to fill out as a business, and just take a look at the information that's going to be requested. It's not a lot. And really, here's a summary of what you're going to need in order to fill out that form, except for the last two items on this list. All the other items here are items that you're going to need in order to fill out the claims form. And really, this is it. This is the comprehensive list. One, you need to know what were the applicable time periods that I was with Blue Cross Blue Shield or a Blue affiliate. What during each of those time periods was I fully insured or was I self-insured? What was the name of the company that was the subscriber or the policy holder? Okay. And for some companies, you're like, what do you mean the name of the company? It's my company, the name of my current company. Well, that's great if that's, you know, if it's as simple as that for you. But for many companies, this could have changed over time. You know, some larger companies, of course, they have complicated corporate structures. They have parent companies, they have operating companies, they have subsidiary companies. I don't think it's safe to assume that, you know, oh, well, we must have been, you know, contracted under our parent company in every case and every year. I think you'll be surprised that may or may not be the case in terms of who actually was the company contracting with the entity. We're going to come back to this concept because it gets even more complicated than that. And this is another area we don't really have all of the answers. Make notes about what are the types of benefits that we had through these Blues affiliates. Was it medical? Did it include dental? Did it include vision? There is a carve out where if you only had a standalone dental or vision through one of the Blues affiliates, then you may not technically be in the class. Although when you get into the weeds of the detail, I think if you had medical at any point during the class period, you may still be eligible to submit a claim with respect to those periods during which you only had dental and vision. But, you know, as you're researching, just be sure to kind of make notes about the other benefits beyond medical. Also, what was the Blue branded entity that you contracted with? Again, that may be something you just automatically know off the top of your head. You've only ever done business, you know, in Ohio. It has to be Anthem. It could never have been in any other entity. But for other companies, it won't be that simple. What was the group number? If you can locate that information, that is a piece of information that's requested on the claim form. These last two items, again, as we've said before, you're actually not required to provide this information as part of your submission of your claim. But in my mind, if you're already kind of going back and taking a look at your records and jotting down some notes, these are two additional things that I would encourage you to try to capture if it's not, you know, too much additional work to do so. I would, you know, make notes about what was the actual, you know, cost sharing allocation split between employee versus employer for the different periods, for the different levels of coverage. And again, that can be quite complicated. And the default allocation, just as a side note, I think, you know, oversimplifies what we all know is a much more complicated setup. You know, you don't just have single and family most of the time. You know, you typically, what I see, there's at least 3 levels of coverage, sometimes 4. I've even seen, I think, 5 levels of coverage. You know, employee plus 1, employee plus children, So it's not clear to me from reading the information on the website how that default allocation really applies. I'm thinking that the single is truly employee only, and family may be anything other than employee only, even though that's sometimes not how we think of family coverage. But again, I would kind of capture as much information as you can about the actual cost sharing allocation that you did with the premium or premium equivalent costs for each of the applicable periods, as well as make some notes about total premiums paid, or in the case of self-insured, total ASO fees paid. Again, these are not must-haves, but if they're at your fingertips, I would capture that information in my notes. The reason I'm saying that is Blue Cross Blue Shield says they have this information. They will use the information in their records. They also have indicated they will share that information with you and give you an opportunity to say, wait a minute, that's not right. You say we paid 100,000 in premiums, we paid $1 million in premiums. Something's not, connecting here. So you will have an opportunity to review that. And if you don't have some general sense of, total premiums paid for that particular period, you won't really have the ability to kind of scrutinize in any way the information in Blue Cross Blue Shield's records. You will ultimately need to decide who's going to sign this claim form. The form itself doesn't specifically mandate that it be like an officer of the company or a certain level of a person at the company, although the person signing, is not signing under penalty of perjury, but is, making a representation saying that to the best of their knowledge and belief, the information being submitted is true and correct. So you need to, just at least be thinking about who ultimately is going to sign this claim form that contains this information. Minor but important detail. If you offered multiple medical, dental, vision benefits for different affiliates, different people based in different geographic locations, different groups of eligible employees, union versus non-union, don't forget to sort of include that in your scope of review. Don't be thinking to yourself, well, I'm just throwing out a name, we've been with UHC since as long as I can remember, but then you forgot that in Michigan, you offered a Blue Cross Blue Shield option because the network for Blue Cross Blue Shield in Michigan was better than UHC's. I don't even know if that's true, but those are the kinds of things that you have to think through. Is don't just be thinking about sort of your primary offerings, but were there offerings for different groups or different geographic locations or different affiliates that you're not sort of immediately remembering may have been with a Blue affiliate. Also, what about acquisitions that you might have made over this period? So you acquired companies who had a contract with a Blue affiliate maybe during this period, even though they're now in your benefit plans and you don't have Blue Cross Blue Shield. In theory, those companies have a claim, may have a claim, and you may be the one that needs to think through that and help initiate the filing of that claim. Also, I just want to mention that there are some specific directions regarding situations in which that would apply to you if you get your health benefits through an arrangement with a professional employer organization referred to as a PEO or a union or a trade organization. You still have your own right to file a claim. You should not be relying on that organization to file the claim on your behalf. And there's a specific box to check on the claim form that says, I received my health benefits through, under an arrangement with, I think it, exactly reads this way. And then you're supposed to identify the name of the PEO or union, et cetera, through which those benefits were obtained. I think, some other things you need to be thinking about. Do you create some type of document, an FAQ, an information sheet that can be provided to employees either proactively or upon request that, contains the information that you've obtained from your research or that you just know off the top of your head. As Brian said, you can almost certainly anticipate that employees are going to call and be asking questions. Was I covered under an Anthem or Blue Cross Blue Shield plan during this time period? What was that time period? What was our group number? Did we also have dental? And employees are not going to remember these details. They may also have questions about, was there a different cost sharing allocation? I want to, select an alternative from the default. I need information to be able to demonstrate that. So you at least need to be thinking about how you're going to answer those questions. Anywhere from any question that's asked should be, the employee should be directed to the Blue Cross Blue Shield settlement.com website, which is not necessarily a bad answer, to, here's some basic information, factual information about our benefits, may or may not apply to you in the plan you were enrolled in, but may be helpful to you. You definitely need to, I think through that and be prepared. People are going to ask questions. So you just need to make a firm decision about exactly how you're going to answer those questions. Okay, I've already mentioned this. The final thing is just, eventually you need to be prepared to receive the settlement proceeds. I can't imagine that anything is going to be paid out based on the level of work that's going to be needed here, even if the settlement is approved in October before the end of this year, although I guess there is a chance it could be paid out in late December, but I'm thinking first quarter. But just the mechanics of, with everybody working remotely, put somebody on notice about a possible check coming in and where should it go and be directed, et cetera. So real quick decision points, Brian went through these. Do you want to opt out of the class before July 28th? Can't really see why you would, but that's a decision you'll need to make. Do you want to file an objection? Again, probably not, but that's your deadline for doing so. And then finally, assuming you are eligible to file a claim, will you be filing a claim by the November 5th deadline? And then lastly, the decision will be, do you just allow the default allocation, or do you want to select alternative allocation and provide information that supports a different allocation? And again, note that your employees are going to be going through these exact same decision points at the same time that you are. This slide talks about some of the complicated questions that can come up around the company, which the form I think refers to as the subscriber. What if that information has changed? What if the company that contracted with Blue Cross Blue Shield in 2009 doesn't even exist anymore? Do you put the name of the new company? If you put the name of the new company, how will Blue Cross Blue Shield be able within its records to affiliate that new company name with the old company name and therefore the underlying premium information? There really aren't answers to this. I don't know to what extent the settlement administrator, if you were to call and ask these questions, might propose a particular way to fill out the form or attach documentation to the form that does show the tie to the current company and the prior company that was the policy holder at the time. That's probably what I would do, put the current company name and then submit some sort of documentation that shows the tie to that prior company, but even that may not be that simple. So still some questions surrounding those types of issues. I'm going to wrap up here with the injunctive relief. So we talked all about the monetary relief. The injunctive relief is really, for the most part, self-effectuating. It will automatically apply to benefit plans and sponsors and presumably benefit plans and plan sponsors as a result of the increased blue on blue and blue on green competition and the elimination of some of the other practices. The one thing you probably do want to do is determine whether you are an identified qualified national account. Again, that list is at the end of this presentation. It's 25 pages long in fine print, but I'd look at that, and then if you are, then know that you will have an opportunity to receive a second blue bid if you go to market sometime after April of 2022 of next year. If you're not on that list but think that you should be, then you'll need to make a decision about whether you want to appeal to the monitoring committee to be added to that list. And with that, I'll just turn right to this list. So this starts out in alphabetical order with the list of those national accounts and goes on for 25 pages. So just wanted to kind of show you what that looks like. So let's see. We can turn to some of the questions. Brian, are you able to see the questions?
Yeah, I don't have my reading glasses on, Laura, so they're actually coming through kind of small on my font here. Like one question, do you have any idea how many self-funded plans may qualify? No, that kind of information has not been provided, but you can imagine there's 37 insurance companies, and the self-funded period goes back 5 years. There's a lot of potential claimants that you'll be competing with for this pool of funds.
Yeah. There's also a question, I think, about what kind of documentation is required to prove a different cost allocation than the default allocation. Let's say prove that the employer paid 100% of the premiums and did not push any of the cost of the plan to employees. It is not clear, and I've actually done a fair amount of digging on the website to see if that was, if there was more detail on that question. So, I don't have a great answer for that.
Laura, I note that the website has a place that allows you to upload additional information. And I think they would be looking for typical and customary business records that indicate you didn't collect any money from your employees for a portion of the administrative fees or the premiums. They left it, my read of it is they left it kind of open. There's an administrator, and then there's a committee set up of some defendants, some plaintiffs, somebody appointed by the court to sort through disputes. It's kind of a business test. What would you want as a business person to establish that you really charged your employees less or more? Yeah, so I would say look for things like your enrollment information, that said you don't have to pay anything, or you pay 50%. That's
what I was going to say. I would hope that a copy of the enrollment materials from that particular time frame that hopefully made some sort of affirmative statement to that effect. Which if you're an employer that pays 100% of your premiums, I don't know why you aren't broadly advertising and proudly advertising that fact to your workforce. But I would definitely start there. What did the enrollment materials that you gave to employees say about what their premium would be, and especially if it's zero?
Here's another question, Laura. So someone said, if the employer paid $1 million in premiums, a simple example, in a given year, and submits claims agreeing to the default allocations, is the claim sum then simply reduced by the 15% if fully insured? The answer is no. It's only reduced to the extent your employees also submit claims, because for every employee who does not submit claims, the employer gets 100%. Even despite notwithstanding the default only applies to the extent you have employees submitting claims for a portion of the funds. So it's a little more complicated than simply reducing this. So the employer could end up getting back money, some of which had been contributed by its employees, to the extent employees do not submit claims. Someone
There's
else.
also,
Go ahead, Laura, you go first.
there's also a question about what if the coverage, the health plan that we have is provided through a private exchange. I don't recall that particular scenario being expressly addressed. I think the words that we had on our slide were right from the settlement website, meaning PEO, trade association, or union, although I think those were intended as examples. You know, off the top of my head, I would have thought that if your coverage is provided through a private exchange, you would be treated like those people whose coverage is provided through a union or a PEO, and you would need to file your own independent claim form and then indicate, you know, in the line that they provide that this was provided through X private exchange. It sounds like that might be a little inconsistent with advice that this client was given. But again, that's kind of off the top of my head, quick reaction.
Here's a good one, Laura. What happens if a covered employee died? Will his or her beneficiary be able to file a claim? That's a good one. I don't remember seeing any guidance on that, and it's probably a question of state law in the particular state. The settlement creates a right for, you know, claimants, and the claim, you know, that person, if alive while employed during the class period, that person has a right to submit a claim, and under most state laws, that person's lawful representative through estate planning and in probate court and whatnot would have the right to assert that claim. So I think we don't know the answer, but my instincts are that the settlement does not address that question, so you would look to state law to decide what the rights are.
Yeah, but I would say, you know, keep in mind, I mean, depending on the specific facts, my guess is that the recovery for any one, you know, single covered employee is probably going to be very small. So you have to weigh, you know, the effort that you just described, you know, going, you know, maybe it involves the estate and that sort of thing against the likely recovery. And again, we don't really know exactly what the recovery amount is going to be for each individual claimant, but I have to sort of believe that for individuals in particular, the recovery is probably going to be, for most of them, pretty small. And so you have to weigh that against the effort that you may need to make to file a claim on behalf of a deceased person.
Laura, here's another good question. If the employer paid 100% of the premium and employees also submit a claim, will those employees' claims automatically be denied? And I think the answer is a pretty simple no. It will not automatically be denied. The employee could submit a claim and click the default option, and their claim will be for, you know, the 15% or the 34%, unless the employer has not clicked the default option, but has instead gone for the alternative option and has proven to the satisfaction of the settlement administrator that the employer paid 100%. And as I read the documents, if an employee submits a claim with an alternative option, the employer gets notified by the claims administrator. And if the employer submits a claim for something other than the default, the employees will be notified. And those two have to be harmonized, and whatever ruling the administrator makes has to add up to 100%, not more than 100%. Okay, so the employer wouldn't get 100%, and then the employee also, well, I asked for the default of 15. If it's already been established to the satisfaction of the administrator that the actual employees didn't submit anything. Yeah. That's my take. I haven't seen a particular scenario answered that way, but that's the structure of things, is that they have to be harmonized and sorted out.
Yeah, and I think that although it's not crystal clear, I think that that result that you just described is what the if-then scenarios, which again on our slides are on slides 19 and 20, which again were just extracted right from the proposed settlement, support what you just described. That ultimately, you know, the claims submitted by both of those, you know, sides, the group and the employees, will be reviewed by the settlement administrator, and a determination will be made. Nope, you didn't satisfy your obligation to prove an alternative, it's the default, or yes, you did satisfy the alternative, and we're going to go with the alternative. And again, as Brian said, I do recall reading that the parties would be notified when, you know, one or the other submitted a claim for an alternative cost allocation.
Here's another good one, Laura. It's the last one in the queue, or the most recent one. If the employer's cost share for medical coverage is determined by the employee's compensation level, I can see Laura smiling already. She loves these questions. How can the percentage be determined as a whole? Can we use averages? As the litigator, I look at that and say, that all sounds like a great reason to just use the default option. They've simplified your life and said, you click this box and we'll just assume that it was a certain thing. If you choose to prove something different than the default, it's your burden to show what it was. And I'm guessing they would ask you for some proof of why they should pay you something different than the default.
Yeah. There's no question this scenario is going to exist, and I even had a slide on this, and then I took it out in the interest of time. But it's, again, you know, these documents have sort of oversimplified reality, which is that, you know, there are plenty of employers out there that have different cost sharing allocation methods that they use for different classes of employees. Could be union versus non-union. Think of COBRA versus active. Think of employers that have structured this so that the premium you pay is based on your compensation level. So it's a great question. It really doesn't seem to contemplate or recognize that that might be a possible scenario. So if you were, for example, to try to submit evidence of each of those different allocation methodologies, you know, would that throw this arbitrator or whatever, whoever the person is that's supposed to be making the decision, into a tailspin? Probably. One of the things that was in my list of things that I would recommend you try to capture, that I kind of glossed over, and this gets to the reason why, I suggested that if you could try to capture for each of the applicable years, not only what was the aggregate premium or fee that was paid. Let's stay focused on fully insured, the aggregate premium paid, but also see if you have records that you could easily tap that would say, in the aggregate, so not on an employee by employee or level by level basis, but in the aggregate, what portion of that total premium was paid by employees? You know, some paying 100%, some paying, you know, nothing, some paying some other percent, and what portion was paid by the employer. And you know, that's the kind of thing that we do as a fiduciary. It doesn't have to be precise, but what would be fair? And you say, well, X percent of the aggregate premium, you know, was paid by the employer, and X percent of the aggregate premium was paid by employees. And when I look at it that way, does this default allocation seem, you know, fair, seem reasonable, seem, you know, close to what that allocation was? I mean, that's how I would go about analyzing that, but it is a great question there.
Here's one I think we can clear up easily, Laura. It's if you're self-insured but less than 5,000 employees, or you were only 5,000 employees for a portion of the settlement period, are you eligible to file a claim? Absolutely yes. So I just want to clarify, the 5,000 employees only applies to one particular aspect of the injunctive relief, the non-monetary relief. Everything else, the money on the money side of things, it doesn't matter how big or small your company is. And in fact, individually, you know, and if Joe Bag of Donuts bought one insurance policy for himself, he has standing to bring a claim and can submit a claim for monetary damages. And if you're a small business under 5,000 employees, you can submit a claim for damages. The 5,000 employee test is simply for whether you qualify for the right to get a second blue bid. They're just saying for the largest, sponsors out there, we're going to let them get a second blue bid. Someone else asked, they joined late. Can I just summarize why we're even here or why this settlement exists? Just real quickly, the Blue Cross and its 37 licensees, the various insurance companies that work under the Blue Cross name, were accused in long-running litigation by plaintiffs of anti-competitive behavior in violation of the federal antitrust laws, basically of creating a monopoly and doing things in a way that drove the prices up for other people, creating billions of dollars of damages. And this settlement represents just a portion of the billions of dollars that the plaintiffs were seeking in damages. They were seeking something like up to $17 billion in damages, and the settlement fund is the 2.7 that we've talked about. Do you see any other questions on here, Laura, you want to answer?
There's a specific question. If our insurance is through Blue Cross Blue Shield of Illinois and they're not listed on the 2-page slide deck, are we automatically not eligible to participate in the settlement? I don't know, Brian, how much digging you did to know, were there a number of Blue affiliates that sort of did not agree to be part of the settlement? I mean, is it safe to assume, well, maybe they just were, not part of the settling defendants?
Laura, no, my understanding, though again, I'm not a Blue Cross expert, is that all of the Blues were sued and agreed to participate in this settlement. But I agree that I don't see Blue Cross of Illinois on the list. So
I think that probably requires just a little further confirmation, beyond what we can do on this.
Well, okay, so I mean, I see on our list that the Illinois licensee is called Healthcare Service Corporation, a mutual legal reserve company. It is quite possible that you think of this as Blue Cross of Illinois, but their legal name is Healthcare Service Corporation, a mutual legal reserve company. And we did have this issue come up in, say, Montana, I think, where I don't see Blue Cross of Montana. Well, that's because in Montana, their legal name is something else. So I don't believe that any Blues are outside the settlement. And I do believe that, guessing if we look up go to the website of Healthcare Service Corporation of America, we're going to find out that's the licensee for Blue Cross in Illinois.
Yeah, in fact, some of our participants are saying here in the question block, Healthcare Service Corporation is the parent of Blue Cross Blue Shield of Illinois. So I think it is, as you suspect, that it's an affiliate and they probably are included even though they're not specifically named in that list.
Yes. And so that goes back to the point of just because Blue Cross doesn't appear in the name on this chart, you should do a little digging. And that I solved the Montana one just by going to the website of, the Montana entity. So you might need to do a little digging to connect the dots. But if anybody does figure out that there's a Blue that is not in the settlement, I would love to hear that, because it's not my understanding, although I couldn't find a universal statement to that effect that I could cite to you. So Laura, with that, it's 2:28. I think we should let our guests go at this point. They will get an email with a link to a recorded version so they can watch you and me speak to their heart's content, Laura. And if you have follow-up questions that are specific to you, we encourage you to reach out to your favorite Thompson Hine lawyer. If you don't have a favorite or you want new ones, feel free to reach out to Laura or me if you're in a pinch with any questions about this. We're happy to help our clients figure out how to navigate through this situation. So with that, thank you, Laura, and thank you to all of our guests for participating here today. Look for an email with this recording and the PowerPoint slides. Thanks.
Thank you.